Today I'm answering an inventor question from Pat. Pat asked the question, I've filed a provisional patent application. Do I also need to be concerned about a non-disclosure agreement? Hi, my name is Carr Ferrell. Welcome back to my channel. And Pat, thanks for leaving the comment. Super interesting question. This question of non-disclosure agreements, or NDAs, comes up a lot. And there are times when you want to get a non-disclosure agreement, and non-disclosure agreements are important. But there are also times when maybe a non-disclosure agreement is not really necessary. Okay, before we get too deep into the question today, let's look first at what is an NDA. Well, a non-disclosure agreement, an NDA, is an agreement, it's a contract between two or more parties in which one party promises to keep a secret given to them by another party. For example, let's say I have a secret and I want to share this secret with you, and you want to receive this secret because we both believe that we can help each other in this relationship. So we create a contract, a non-disclosure agreement, in which I agree to share my secret with you, and you agree to keep my secret private, not to share my secret with others. Now, it might be that you also have secrets that you want to share with me. We call this a mutual non-disclosure agreement. It's a contract where we both agree to keep each other's secrets. Like any other contract, it's legally binding. If either of us breaks the contract, the other party can sue that person in court for money or other damages. Okay, that's the non-disclosure agreement. For reference, I've included a link to a mutual non-disclosure agreement in the description section below, so you're welcome to take a look at that. But just keep in mind that these NDAs are legal contracts, and if the contract is important to you and to your business, it may be worthwhile having your attorney look over the contract before it gets executed. Okay, now let's talk about the provisional patent application. Your provisional patent application gives you a priority date for the protection of your invention in the patent office. Once you file your provisional patent application, you are patent pending, and you block all others from getting a patent on that same invention. So in many respects, you are protected from the moment that you file your provisional patent application. But there are still reasons that you may want to get a non-disclosure agreement. For example, it may be that you just want to stay in stealth mode. You don't want the public to know what you're working on. And we see this with Apple Computer and many other manufacturers all the time. They don't want to cannibalize sales of current products by announcing future products too early. Secondly, non-disclosure agreements test the seriousness of collaborators and partners. It makes the person or company that you're collaborating with, the one that you're entering into the agreement with, really think about, are they serious about this relationship? Do they really want to go through the hassle of entering into the non-disclosure agreement? And another reason that you may want to enter into a non-disclosure agreement is that this is a cautionary ceremony, a reminder of the seriousness of the secrets that are being shared, that you intend for the information to remain confidential. There's a formality associated with the non-disclosure agreement. It's a contract, and it's a bond between the parties. But there are a couple of good reasons why you may just not want to enter into a non-disclosure agreement contract. One of those is that it's a hassle. It's a bit of a imposition to ask the other party to sign a non-disclosure agreement, especially when discussions about the relationship are going hot and heavy. And you sort of spoil the mood by saying, well, before I disclose any more, would you be willing to sign a non-disclosure agreement? Part of this is that many companies have policies where their legal departments are required to review non-disclosure agreements before they're executed. So that can add delay and bureaucracy to the process of negotiating a deal. And if you don't already have a lawyer spun up on the deal or maybe have in-house counsel, this will mean there's potentially some extra cost associated with bringing on counsel to review your non-disclosure agreement before signing. And another good reason that maybe you just don't want a non-disclosure agreement is that you want to share your invention, your product with the public anyway. There's no point in having a non-disclosure agreement because you want the public to know about the product that you're selling. But of course, the non-disclosure agreement may not be just about the invention or the product, but also covering the terms of the relationship between you and the other party. So you may want the legal details between you and the other party to be held in confidence, even though it's desirable to have details of the product and the invention in the public. So in summary, by filing the provisional patent application, the details of the invention are protected. You have a priority date with respect to filing a patent application and protecting the invention. However, a non-disclosure agreement may be useful for other reasons, keeping the invention or the product under wraps until you're ready to release it, or in protecting and keeping in confidence the relationship, the legal details between you and the other parties involved. Okay, that's all I have to say today about non-disclosure agreements and the relationship to patent applications. If you or your business needs help with its patent application or its patent portfolio, or you need help with your non-disclosure agreement, I'd love to hear from you. You can reach me at the email address below. In the meantime, I'll see you on the next video.